I know we're starting an hour late, but I've adjusted accordingly. Given our first panel, there's no need for presentations because you were here last time. So I simply want to thank you for coming back and announce your names. Mr. Matthew Taylor and Joanna Wells, you were here last day. For Mr. Fortin, we have one person virtual, and yes, he has been tested and it works fine.
Thank you, Mrs. Chair, but I hope I'm not the only one to take advantage of that.
No, it's a fair point. So what we will do is have a 4-minute round with the witnesses, and I'll start with that, and it'll be 1 4-minute round. So hopefully, our apologies for that. And I'm going to start with, welcome to meeting number 76 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference from the House adopted by the House on October 5th, 2023, the committee's meeting in public to continue our study of the subject matter to Bill S-12. After the first panel, I'll ask for a motion on Bill S-12, but I think right now, due to the fact that we're so delayed, we'll simply start with the questioning of the witnesses for 4 minutes each, and I will start with Mr. Van Popta, please.
Thank you, Madam Chair, and thank you, witnesses, for being here. On behalf of all of us, I apologize for the delay, but we are doing very important work in the House of Commons today, voting on precisely this bill that we're discussing here today, Bill S-12. So thank you for being here, and thank you for lending your expertise to this very important discussion. So S-12 is about amending the criminal code as it relates to the National Sex Offender Registry, and that discussion was instigated by a Supreme Court of Canada decision, R versus Nudlovo. And I just want to quote from the minority. It was a split decision, 5-4. And the minority cited evidence that apparently was before the trial judge that, in their opinion, offenders convicted of a sexual offense are 5 to 8 times more likely to reoffend than those convicted of non-sexual offenses. And they also said that it cannot be reliably predicted as at the time of sentencing which offenders will reoffend. Then the minority came to this conclusion: in the face of that uncertain risk, Parliament was entitled to cast a wide net. Now, we had the Minister of Justice here just the other day, and he made reference to data, social science, that in his opinion supported this current legislation, Bill S-12, which I would say has a lower standard as when it comes to making it mandatory to have people registered to the sex offender registry. Are you aware of that data that he was referring to, and does it contradict the evidence that apparently was before the trial judge that the minority judges referred to?
I'll take that. Thank you for your question. So I think I will start by answering the question by reiterating what the minister said when he was here, that everybody who receives a conviction for a sex offense, if C-12 is enacted, will be required to register unless they can demonstrate that the registry is overbroad or grossly disproportionate. So it's a very strong presumption of registration for those offenders. The data that you cite and that the minority articulated were the arguments that the Attorney General of Canada made before the Supreme Court when he intervened to defend the legislation, when the Supreme Court heard arguments on that. That data was not sufficient to uphold the law. So the data that is now being relied on for the 2 categories of automatic registration relate to repeat sex offenders, and those individuals pose an even higher risk of reoffending than first-time offenders, which was the target of the original legislation. And for the other category of automatic registration for children, for victims under 18, a sexual interest in children is a very well-validated risk factor for sexual recidivism. Coupled with the 2 years or more on indictment, it is expected that that constellation of factors together will provide the evidence that the government would use to justify those two automatic categories. But everyone will be presumed to be registered.
Right. Okay, so I want to zero in on sexual offenses against children. So it's the S12 requires it to be mandatory that a person's name is listed to the register if they were convicted of sexual offense against a child, but only if it was prosecuted by way of indictment and the sentence was at least 2 years. So why not for offenders, child molesters, who were prosecuted by way of summary conviction? Aren't they also equally dangerous?
So they will be presumed to be registered under the proposals in S12.
Very quickly, please.
I think that is the answer. They're all presumed to be registered, and what the bill does is list risk factors as well for judges to use to exercise their discretion, and those factors were intended to counter the criticisms, the concerns raised by the minority judgment, to curb the risk that they saw in judicial discretion.
Thank you very much. I'll now move on to Mr. Mendocino.
Thanks very much, Madam Chair. Thank you to the officials for appearing today. I understand, Mr. Taylor, it was your birthday today or yesterday? Happy birthday. I'd like to also take a brief moment to thank the survivors and the victims who are present here to testify. On behalf of the members of this committee and all parliamentarians, we want to thank you for your advocacy. I can tell you in my experience, not only in this job on the Hill, but before as an actor in the criminal justice system, that your work is incredibly important to this legislation, and we thank you very much for bringing forward the ideas that you're going to articulate later today. Colleagues, we know that Bill S12 would propose to do three things. One, strengthen the Sex Offender Information Registration Act, make certain amendments to the International Transfer of Offenders Act, and then finally, strengthen some of the rights that are or ought to be afforded to victims in the context of criminal justice proceedings. And I think we can all agree that there is still a lot of work to be done there. I want to zero in on the concerns that have been expressed by victims, advocates, and survivors themselves around how we can ensure that they are provided with timely and accurate information around applications that involve publication bans. And a couple of days ago, we heard from the minister who expressed a concern with one of the amendments that had been put forward by the Senate, which would require that Crown prosecutors communicate directly with victims about said publication bans. Now, before I get into those concerns, and I'm going to give the officials an opportunity to elaborate on that, Madam Chair, I think we can all agree that it is important that that victims should be treated with professionalism. You'd agree with that? And with courtesy. But more importantly than that, with sensitivity, and in particular taking a trauma-informed approach. So that's regardless of who is communicating with them, whether it is a Crown prosecutor, a member of the law enforcement branch, a member of the profession, any of the social service providers in the system. I think we can all agree that we have to do better there. That said, the minister did say that he was worried that the Senate amendment, as expressed, would infringe prosecutorial independence. Now, I'd ask you very, very briefly in a matter of seconds, just tell us what the job of a Crown prosecutor is, and then I'll come back to you to ask a follow-up.
Thank you for the question. I mean, very briefly, the job of the Crown prosecutor is to present their case to the court concerning the guilt or innocence of somebody who's been charged with a crime. They represent the public interest. That encompasses, of course, concerns of the victim, but is not uniquely about concerns to the victim.
And to be clear, the Crown does not act as a lawyer to any individual party. They are principally there to represent the public interest, as you said.
Correct.
And that is part of the reason why the minister expressed that concern. So let's get to the solution. How do we ensure that victims get timely, accurate information when it comes to publication bans to ensure that their rights are being upheld?
So a very good question. The bill is introduced, tried to do that. It acknowledged the increased requirement for all of those in the criminal justice system to to do more to support the interests and rights of victims. The Senate amended the bill, felt that it could go stronger in that respect. It did that. So there are more onerous obligations on both the court and prosecutors vis-a-vis victims and publication bans. The concern that the minister spoke to is a concern that is not uniquely his own. It is a concern that's been identified by provincial attorneys general in other jurisdictions, Ontario, Nova Scotia. The concern is that the provision could be interpreted in a way that suggests that a prosecutor is providing legal advice to a victim about what they can do.
I know we're on a very condensed timeline, but with regards to providing copies of publication bans to victims, if that's not something that's in the legislation, is there another way that we can provide support to victims? Thanks very much.
Yeah, absolutely. I mean, victim support workers are able to provide information to victims, copies of publication bans. Thank you.
Thank you for that. So, Monsieur Fortin?
Merci.
Thank you, Madam Chair, and happy birthday, Mr. Taylor. My friend from the Conservative Party didn't have that information, but I'm sure he would have wished you a happy birthday too. Mr. Taylor, Ms. Wells, I'm also concerned by this aspect of the information for victims. It seems critical to me. S12 doesn't deal only with this. It's also with dealing with the sex offender information registration. And I think everyone agrees on that, so I don't want to waste time going back over that. But on the issue of information given to victims, I heard the minister yesterday, and my colleague from the Liberal Party referred to this. He raised issues of conflict of interest, and I listened to Mr. Mendocino's question that you answered concerning what the job of the prosecutor is, of the Crown. So maybe you'll correct me if I misunderstood, but I've always heard that the Crown attorney had no case to win, if you will. His job is to ensure that the facts are established clearly and completely before the court, and that so that a fair decision can be arrived at. So the issue of conflict of interest seems to me to be a rather distant one. I understand that there might be a conflict and that the Crown attorney must ask himself questions. How can I make sure that the victims understand the whole issue of the publication ban, and I don't want them to come back to me 2 years later and say, this is what your colleague told me. So it is a concern that I consider to be legitimate, but it seems to me that there would be a way of preparing for that kind of situation. And I think, amongst other things, that the information that the Crown gives to the victim are more or less the same in all cases. So there's some adjustment to be made on a case-by-case basis, but there might be some way of putting this information into some kind of format that can be given to victims. So I'd like to hear what you would say about that. Is there some way to ensure that victims are well informed without, at the same time, the Crown attorney placing themselves in a situation of conflict of interest?
Question, vous avez expliqué la...
You explained the role of the Crown effectively, and there is, in fact, there are options for victims to receive information concerning the criminal justice system. So I think that the government has recognized that it's important to find a balance between the information that they share with the victim, but at the same time respecting their role as the Crown. So when we were before the Senate, the debate was really concerning the sharing of information and the role of the Crown. But I believe that this issue really concerns the text that exists in 3 different places in the bill, in English,
disclose information that is subject to the order without failing to comply with that order. En français, ils peuvent
In French, they can give information if they respect this rule. So I think the question is if the text is not appropriate or to share with the victim. Thank you very much.
Monsieur Taylor and Monsieur
Thank you, Mr. Taylor and Mr. Fortin.
Garrison.
Thank you very much, Madam Chair. And I just want to say for the record that I feel that my privileges as a member of this committee were breached by the early start of the committee. We have an agreement, which has always stood in this committee, that committee will not begin until 10 minutes after a recorded vote in the House. I was in the House voting. And so I apologize if some of the things I'm about to ask have been covered. I'm prepared to let it go at that. Thank you for being here again. Always good to see you. I asked in the other session the other day when the minister was here about the number of times that publication bans are applied, and they were really, I think I wasn't particularly clear. I'm asking two questions there. How many times are publication bans used, and how many times are publications automatically used in these cases? So I was really trying to ask two things there, and I know somewhat what your answer is, but I'd like to hear it.
Thank you for the question. So as I think the minister articulated on Tuesday, we don't have national statistics on that information. After the committee appearance on Tuesday, we went back, we asked Statistics Canada what information they do collect. The reason they don't collect that information that we were given was because this is a procedural order that is made in the course of a trial, and so they don't have that data. Now, that's not to say that that data can't be collected. It's just that currently they don't collect it. We would have to work with provinces, courthouses to be able to collect that information. They do. I would say that my expectation is publication bans are imposed routinely every day across Canada, but what that number is, I don't know. They do collect information on the offense for breaches of publication bans, and that is fairly limited. And if you want that information, I can provide it, but I know time is short.
Can we just go back, though? They do collect information on the number of sexual assault cases that are dealt with, and if they're routinely applied, which we've heard a number of times, then we should know roughly how many times they're used, if we know the number of sexual assault cases.
Yes, absolutely. They do collect information on the number of charges that are laid by police officers and the number of outcomes reported by courts. So I mean, I think your question speaks to the capacity to collect that information, but they don't currently collect that information.
But they collect information on the number of sexual assault cases that go to court.
They do. They collect the
And so we should have that number.
They don't currently collect it. That's all I can provide.
Okay. Let me move on from that. But I think I guess what we're establishing here is that we know anecdotally that these bans are routinely put in place, and so victims of sexual assault are regularly subjected to the ban without being informed under the current regulations. So, are there any situations in which a ban on publication can be used under the current law to benefit the accused? And does this happen?
So I would answer it this way. Publication bans are imposed for the benefit of the victim or the witness, first and foremost. The interests of the accused are not taken into account in terms of determining whether the publication ban could be imposed. Incidentally, the consequence of a publication ban imposed to protect a victim could also result in protecting the identity of the accused if reporting on the identity of the accused would identify the victim.
And so then we shouldn't be seeing cases in court where the defense counsel for the accused is allowed to make representations on the publication ban?
Correct. So the accused doesn't have standing in these matters, and as I said, a publication ban doesn't benefit them. And we do have some case law. I would just have to dig it up for you.
It's just that, again, anecdotally, we have sometimes heard where defense attorneys have made presentations in court on publication bans and their lifting or their variants. And so that's something that should not be happening. Is that what I'm hearing?
Correct. The law is clear that a publication ban is in place to protect the identity of a victim or witness and not to benefit the accused.
And so would the text of S12 do anything to clarify that situation?
There are amendments in S12 that were passed by the Senate that speak to the issue of the accused. The concern that was discussed in the Senate when those amendments were debated was whether that would suggest to the courts or the criminal justice system that an accused currently has an interest in these proceedings and that Parliament is presumed to be acting for a reason. But the counterpoint was made that this was really meant to reflect the status quo of the law.
In terms of the requirement that victims be informed when there's a publication ban, does the current text of S12 require that victims be informed that they have a right to request a publication ban if they should desire? Or is this simply an after-the-fact kind of notification?
Yeah, there's a number of different places in the bill that speak to the obligations of the court and the prosecutor to engage with the victim. There is language that speaks to the obligation to inform a victim or witness of their right to apply to revoke or vary a publication ban.
And I know I'm perilously close to the end here. I ask just one more brief question. Are there, in the current legislation, are there any restrictions on varying or lifting publication bans?
So the bill seeks to codify a process for revocation or modification. Today, it is a common law process. It applies where it can be shown that there's a material change in circumstances. The courts have acknowledged that if the recipient of the publication ban no longer wishes to have the publication ban, that constitutes a material change in circumstances. The bill would codify a practice that would require the publication ban to be revoked or modified at the request of the victim or the witness, provided it doesn't impact on the privacy interests of another person protected by a publication ban.
Thank you, Mr. Taylor.
Sure.
Thank you.
Thank you.
I'm sure you're around if somebody has any. Yeah, okay. No, that's terrific. Thank you so much to both of you for coming. We really appreciate that. You're free to go.
Thank you.
You're welcome. Subject to anybody contacting you outside of the committee.
Happened here today.
I have only probably 60 seconds. Given the fact of what just happened in the House and the bill now coming to our meeting, I need someone to move a motion that all testimonies received in our study on the subject matter of Bill S12 be deemed heard in our study of the said bill.
So moved.
Mr. Maloney, thank you very much. And please take a look if you have not. I think it was sent to you, but also on your desks, there's a calendar there. We really worked very hard in anticipation of this coming so that we don't waste any time because we kind of foresaw that we might be starting late. If you take a look, we have a week of break. Happy Thanksgiving, by the way, to everyone. And when we return the week after that on the 17th, deadline will be at noontime to submit amendments for S12. We will then, on October 19th, have our study S12 clause by clause. And on the 17th, we'll have a meeting, as usual, with witnesses on S12. Does that work for everyone?
Yes.
Okay, thank you very much. We now have 3 witnesses, so. Yes, please.
On the calendar circulated on the 19th, it says there's a meeting. And so what you're saying is that, just so it was clear, that testimony will conclude on the 17th.
We
And
would
that-
have to if that's, yes.
But then my point then is that testimony will conclude after the deadline to submit amendments. And that's problematic.
Okay, Mr. Well, what do you propose?
Well, I don't wish to cause inordinate delay here, but I think at least the end of the day, that day, would allow, if something comes up at that meeting, for people to give notice of their intent to do amendments. I just think it's not fair to witnesses that appear on that day to not have their testimony affect what we might be doing in amendments.
I agree. You're right.
It's here.
So clerk's telling me that they require 48-hour notice, but there's always a possibility to bring amendments on the day as well. Does that?
The assurance I was.
Okay, thank you. All right, that's perfect.
It's not-
Obviously, you would send them probably ahead of time, but yes. Yeah, Mr. Brock?
Yes, thank you, Madam Chair. Just for clarification, then, the October 24th and 26th on this calendar, are we suggesting that we'll move into another study, the next study?
So what we will
list?
probably then do is have a steering committee meeting, and we'll decide that on the 17th so that we can decide what needs to happen.
Okay,
Yeah,
thank you.
because we haven't gone beyond S12 at the moment. You okay with that? Thank you very much. Okay, welcome to our witnesses. Listen, apologies. Today was not a normal day, so in terms of timing, we appreciate all three of you being here. I will introduce all three of you. You were with us before. We very much appreciate it, and I concur wholeheartedly with Mr. Mendocino's remarks earlier. Very much appreciate all the work that you have done with this study. So with us, we have Megan Stevens, criminal and constitutional lawyer, Megan Stevens Law. Morel Andrews, member of My Voice, My Choice. Suzanne Zakour, Director of Legal Affairs, National Association of Women in the Law. And I'm going to leave it up to you. I know you understand the time constraints we're under. Again, Mr. Garrison, apologies, but I had 5 people come to me and say we need to conclude at 5:30 today before we started. And so we sort of shrunk as much as we could. So I'm going to leave it to you. I know you all have prepared statements. Take whatever time you need up to the 5 minutes. And if you take less, that's quite all right as well. And then we'll move into questioning as best as I can sort of do the minutes. So thank you very much. I will ask Ms. Stevens to please commence.
Thank you so much. Good afternoon. Thank you for having me here today. In my limited time, I want to focus on the treatment of publication bans in this bill. My view in relation to pub bans has been informed by my work over the last 2 decades in criminal and constitutional law. I was at Crown for more than 10 years. I was then the executive director and general counsel at LEAF. And in January 2021, I launched my own practice to assist women and gender diverse people with their encounters in the criminal justice system. I now routinely represent complainants in sexual assault proceedings, including in relation to lifting of pub bans, often on a pro bono basis, and also act for criminal defendants, predominantly in the appellate context. Through that work, I've seen firsthand that our legal system really struggles to respond in a trauma-informed way to prosecutions of sexual offenses. It's no surprise to me that sexual assault remains among the most highly gendered and underreported crimes. When pub bans were first introduced some decades ago now, they were meant to encourage the reporting of sexual offenses. And for complainants, knowing that a pub ban is available does help some of them come forward to report. But not every complainant wants a pub ban. Many find comfort by being able to share publicly their experiences with others. For those complainants, a pub ban that impedes their ability to do that can be re-traumatizing. All the more so when the bans are imposed without their knowledge or agreement, or when they realize that the ban could actually lead to their criminalization. With that in mind, I welcome the spirit underlying the proposed changes that would follow from enacting this bill. Complainants need more agency when it comes to the imposition of pub bans, and they need more information to exercise that agency. If a pub ban has been imposed but a complainant doesn't want it, it needs to be easy to vary and revoke it, And perhaps most importantly, they should never be criminalized for failing to comply with a pub ban on their own identity. Bill S-12, as passed by the Senate in June, I think appropriately targets most of these concerns. It's much improved, but I want to talk about one key problem that I think remains today, and I heard some of this coming out in the questions of the justice officials. Bill S-12 would amend the code to impose a duty on prosecutors to inform the judge after a pub ban has been ordered that they've taken steps to inform the complainant or witness of a number of key things. Currently, it's the existence of the order, its effects, and the circumstances in which they may disclose information without being in noncompliance of the order. It's to determine whether the person wishes to be the subject of the order and to inform them of their right to apply to revoke or vary the order. I 100% agree. A prosecutor is well placed to inform a complainant about two key facts: that the pub ban has been imposed and that they have the right to apply to revoke or vary that order. But that information isn't currently being shared routinely with complainants, even though a pub ban is routinely being imposed on almost every single sexual assault case that happens in this country, but they need that information. I'm concerned that the current language goes beyond a duty to inform by blurring the lines between a discussion about factual issues and an update into a discussion that requires them to dispense legal advice. The prosecutor is not the complainant's lawyer, and they are not in a position to give a complainant independent legal advice. I've worn both hats. They're not the same thing. Requiring a prosecutor to explain the effects of the ban or the circumstances in which they can speak without risking liability, that's crossing the border into legal advice. A complainant may have questions to decide whether they want the ban to remain in place. They really need independent legal advice to weigh those competing considerations. They can't get it from a prosecutor. Discussions like that would be risky, not just for prosecutors, but for complainants. It could trigger disclosure obligations on the part of the prosecutor, and it puts complainants and prosecutors into a potential conflict of interest, since choices a complainant might make could affect the strength of the prosecution. The bill really needs to be amended to impose a more limited duty to inform that would require prosecutors to inform complainants, yes, that the ban exists, that it can be varied and invoked, and that they are entitled to get independent legal advice to make an informed decision about whether they want it to continue. So that brings me to my final point. You must accompany this bill with meaningful funding to improve access to free independent legal advice for complainants and better resourcing of organizations that support them. Complainants who can access independent legal advice from trauma-informed lawyers and community supports are much better equipped to manage the stresses of criminal proceedings. Thank you. I look forward to your questions.
Thank you very much. Exactly 5 minutes. Ms. Andrews, please.
Thank you. I would like to thank the Algonquin and Anishinaabe people whose land we gather upon today. I will once again encourage this committee to integrate the calls to action from the Truth and Reconciliation Commission into your report. I'll be quick, skip over some things, but I just want to make it clear that I do not speak for all victims and cannot come close to encompassing the lived perspectives of those who face a number of barriers in accessing the system and accountability for the crimes committed against them. I think the Senate did good work on S-12, but we're here to ask you to be even more ambitious. From our perspective, a better bill would feature amendments that do a few more things, like ensuring that prosecutors are directed to immediately inform the victim of their right to request a publication ban before it is ordered. Right now, the bill talks about judges doing that. It's not realistic. It doesn't happen in real life. Someone needs to tell victims that they have the right before the ban is being put on their identities. You should clarify that Section 486.4 is available. The publication bans are available for witnesses under the age of 18 years and victims of sexual offenses, because there's still confusion about this in the system. The bill should require prosecutors to also act in accordance with the wishes of the victim. We like to use the word consent, but for some people that might not make sense in the context of the criminal code, but the wishes of the victim should matter. You need to make sure that this is in the bill and that there isn't justice system actors like judges or crowns who are acting without the consent or the wishes of the victim taken into account. We want to make sure that publication bans are not put on the identities of victims who have made it clear that they do not wish to be subjected to such an order. We want to make sure that victims are provided with a copy of their publication ban. Victim services simply do not give us that information. They don't know about publication bans. They are not equipped to do so. It doesn't happen in real life. I want to make sure also that the way that applications are dealt with for sexual offense victims is separated from Section 486.5 of the Criminal Code. Right now, Bill S-12 lumps discretionary bans for any justice system participant with this type of publication ban for sexual offense victims, and it doesn't make sense to have them combined. You should separate them and make it clear that the only persons, that there are only limited factors that a judge can consider when someone comes to them and asks them to remove their publication ban, if it has to go to a hearing. But ideally, victims should just be allowed to have their publication bans lifted without having to go to a hearing. And finally, we want to make sure that you expand the limitation section to ensure that trusted people, including professionals who provide support to victims, are not criminalized for communicating. Right now, the bill carves out a limitation for victims sharing their own information, but people who have to converse back and forth with victims when they need support should not be criminalized. We want to make sure that there are no more egregious delays for victims removing their bans like what happened to Patty or Marika. We don't want any more victims having to hunt and go to the court to try to find their publication ban orders like what happened to Deborah Lynn this very week. We want to make sure that there are no more defense attorneys who are reintroducing publication bans on the names of victims who have already had their pub bans removed, like what happened to Cassandra last month. And we want to make sure that crowns are no longer acting on assumptions without involving victims, like effectively every single person that we have been connected to. These suggestions are crowdsourced. They are based on the lived experience of victims. We have done our very best to consult these recommendations very widely, but it is literally impossible to capture the nuance of every individual's issues, perspectives, and interactions with the legal system. We've done everything humanly possible to give you amendments on paper and to help you in this process, but the reality is that this should not be our responsibility as victims. We are not lawyers, but we are trying to do our very best to help you. Inevitably, some people will say it's not good enough, but we're here now and we're doing what we can. Quite honestly, the last year and this process has left so many of us feeling re-traumatized, depleted, and extremely tired. And we have been placed in the very unenviable position of wondering if tweaking on the margins of the current criminal code will be good enough. For that reason, these recommendations are not a panacea. This Parliament will still be confronted with the fact and the realities that complainants face a shameful amount of barriers throughout the continuum of seeking help and accountability and long after. Your police still don't believe us. Your Crown attorneys are not trauma-informed. Your judges don't understand how to properly apply the law at our expense. And you have not invested sufficiently in the resources outside of the system that can be there to provide important support that is culturally appropriate for victims of all different kinds of backgrounds. After Bill S-12 is complete, you will still have work to do, like education for Crown attorneys and judges, implementation guides for the provinces and territories, a review of legislation to make sure that you get it right, and the production of accessible information for victims who deserve to know what is happening to them in the system. The people behind My Voice, My Choice have done everything expected of us and far beyond, to be honest. I know that you are facing tough deadlines, and I know that this is not the ideal way to write a bill, but here we are. This is what we have. I want you to continue to consider our amendments, as many of you had, and I want to know that they matter. I want to know that the stories we've shared with you matter. So please do the honorable work and collaboration across party lines and take this seriously, because if you do, and you amend the law so it's at least a bit better, we can finally rest and take some time to do the healing that a lot of us still need to do. Thank you.
Thank
Merci
you, Ms.
beaucoup.
Andrews. And the clerk tells me you've sent something in just recently, but it'll get translated and circulated to everyone on the committee. Ms. Zakour?
I'll be very brief because I think everything really has been said. I'm Suzanne Zakour, and I'm the Director of Legal Affairs for the National Association of Women in Law.
Un organisme à but non lucratif.
It's a non-profit organization that is advocating for women's rights in Canada, including in the legislative process. So it's always with great pleasure that I come here to discuss with legal issues with you that are gendered and that affect women in Canada. We've already submitted, in collaboration with other organizations, a brief when the bill was studied by the Senate. And we worked in collaboration in order to put forward three important
The need to ensure victims are not criminalized for failing to comply with a publication ban. We highlighted the need to clarify and simplify the process for revoking or varying a publication ban. Quite frankly, it needs to be much clearer. These are not lawyers necessarily who are engaging with this process. And we highlighted the need to ensure that victims are adequately informed throughout the process. Our position is that the Senate amendments are positive and have brought about a lot of progress in this bill to fulfill these three objectives. There's a minor detail I'll call your attention to. It's the language of a person being subject to the order rather than subject of the order in the limitation section of the bill. I'm not so concerned due to the fact that the French version is correct, but still we know how difficult this process is. So if we can avoid litigation or having to do complex interpretation, just clarify that the limitation applies to people who are the subject of the order, whose identity is protected by the order, rather than subject to the order, which is everybody, because everyone needs to respect a publication ban. I have more to say, but I know we're pressed for time, so I'm going to stop here and we'll be happy to answer questions. Thank you.
Thank you very much. If it's okay with everyone, can I go for the first round, and maybe the only round, but 4 minutes each? Does that work for all of you? With that, yes? So, Mr. Brock.
Thank you so much, ladies, for your sage advice and the information and the passion by which you bring such intelligence to this study. It is extremely disappointing as a parliamentarian that we're trying to shove the passage of this bill literally at the 11th hour when the government had an entire year to get this right. We've got 13 days to get this passed. We've got one more day of witnesses. It's unfortunate that we are cutting short a very important study in this fashion. Ms. Andrews, again, you bring nothing but courage to every committee that you've appeared in, that I've had the privilege of hearing from you, had the privilege of questioning you. You bring the truth, you bring strength, and I have nothing but high praise for the resilience that you have shown, not only as a survivor, but now as an advocate for change. Every parliamentarian should be listening to your words because this is an opportunity for us to get this right. So I've got very limited time. You've mentioned a number of amendments. You talked about amendments that you spoke to at the Senate stage. What is the most important amendment that you think that we should seriously give consideration to strengthening this bill?
Thank you. It's hard to choose just one, quite honestly. But if I'll go really quickly, you all have the package I've sent around. So I think if there's 4 real things that you need to kind of lend your minds to, it's making sure that prosecutors inform victims and are acting on behalf of their wishes. Second, to allow for the application process to be clarified. It's really important you get that right and that judges are given as narrow a scope as possible to potentially deny a victim with their freedom of expression. We want to make sure that everyone who wants to speak should be able to speak, and that there should no longer be this ability for judges to deny victims being able to actually talk about their experience. I think those are the two off the top that I think are really the most important, because if you get consent right, people can make a decision before they have a pub ban put on their name. And if they do have a pub ban put on their name and you get the application to remove the pub ban correct, you won't have addressed every problem, but you will have done good work.
Time left, Madam Chair. You identified in your opening statement an issue that needs to be fleshed out a little bit, and it's in response to my colleague, Mr. Gerritsen, where he asked the officials, how many times are these publication bans granted? As a former Crown attorney, I can say to you, I can only speak on behalf of the province of Ontario, every single time that I was in bail court or in remand court for the first time dealing with a sexual offender for an adult victim or a child victim, we were instructed by policy to ask for those publication bans. And I see Ms. Stevens shaking her head because she's a former colleague of mine. So it's something that federally we cannot work on. Provincially we can. We need to broker a relationship between the feds and the provinces to ensure best practices are adopted across this country so there is uniformity, that at the very earliest stage, using all the tools that we have as prosecutors to get that input very early from the complainant is key. So I thank you for raising that as an issue, and that's probably my time. Thank you.
Thank you very much, Mr. Brock. Madame Brière, s'il vous plaît.
Thank you.
Ms. Brière.
Good afternoon, everyone. I just want to say I admire you, Morel. We met at first study, and all these women for coming out of the shadows. On sait que les...
We know that pub bans are related, and they're connected to many other components that are critical to have a process that's really focused on survivals, that the victims. So those components can include, for example, independent legal services that are free. You mentioned it, education as well for Crown attorneys and judges. What do you think? I mean, how could we better incorporate that kind of assistance into the process?
I think Megan would be really well suited. I know she's done a lot of work with judges on education, and I would pass it over and defer to her as an expert.
I do think there needs to be more thought given to the role of independent counsel. The role of complainants counsel is a relatively new and unusual role in the criminal justice system. Typically, we think of prosecutor defense counsel. There is a huge need to provide independent legal advice to people who have survived sexual violence. And I think at the very beginning of this stage of the process, I come across a lot of clients who probably, if they had known what the process would be like, might not have chosen to come forward and report. And I know pub bans are intended to encourage reporting, but I think the most important thing is agency. They've experienced something where they had no control, and they come forward and report because they're told that's what they should do, and they end up in a process where they lose complete control over everything again. They don't get a voice, they don't get a say, they don't get informed about what's happening, even by well-meaning prosecutors and victim services. Everyone is so busy. And so I think at the very outset, they need to be able to access independent legal advice I'm in Ontario, so I only know about the program that exists in Ontario. There is a program, it started as a pilot project that the provincial government rolled out across the province. So every victim of sexual violence in the province of Ontario is, in theory, entitled to access 4 hours of independent legal advice. You apply for a voucher, you can get it. There are 26 lawyers, maybe 27 in the whole province who are on that list right now. I'm not one of them. I can't get on the list because the list was put together in 2016 when I was a Crown. And so people are told that they have access to something, but they can't even access it. And that's just Ontario. And I do think there's a real need to have people help guide you through the system, to explain what the process will be, and whether it is in relation to pub bans, to be a conduit of information to the Crown, because the Crowns don't want to talk to you and turn themselves into a witness or potentially trigger disclosure obligations. So, that's just one way of thinking about it. I do think, further training for everyone in the system, including Crowns, about what it actually means to be trauma-informed, and judges as well, is an important thing. I know oh, sorry.
No, I was going to let you finish your
Okay.
train of thought, but it's time.
There has been training that has been implemented for federal judges. When people are applying, they have to agree to that training. But the majority of cases actually proceed through provincial courts. That's outside your jurisdiction, but it is a problem in terms of making sure that training hits at all the right points in the system.
Thank you very much. Monsieur Fortin?
Mr. Fortin? Thank you, Madam Chair. And thank you to all three of you, witnesses. Your testimony is so important, and we have so little time. I won't waste any more than necessary, but I agree with what my colleague, Mr. Brock, said. I can't even explain how we could have waited 6 months after the Supreme Court decision and the tabling of this bill in the Senate. We literally lost 6 months, but here we are today, and we're having to rush you along to testify, and I think that isn't very classy, and I apologize on behalf of all of my colleagues in Parliament. I'm sure they're no happier about it than I am. Having said that, we don't have much time, so I'm not going to deal with all the aspects we have already covered. But there's one that we haven't really discussed, and I'd like to hear you talk about it. And by the way, Ms. Andrews, I have your suggestions of amendment in English and in French. That's well done, and I wanted to mention that. Ms. Stevens, if I may, there's the issue of non-publication bans and when there are multiple victims. So you might have a young girl who's 14 years old, a woman who's 20, another who's 30, or maybe when some might say, I want the ban for my family's peace and quiet, and others say, no, I want to speak about it. So there are many different perspectives, all of which are valid. And so I'd like to hear you speak to that. How can we organize a ban when there are several victims who have different perspectives and different needs? Because that's another thing. If you're talking about a 14-year-old girl, you have to understand that you have to protect her, whether she wants to be protected or not. I'd like to hear you on that, please. I will answer in English, please. I could try in French, but it will take time.
So I think organizing them can be difficult and complicated, and no one has really turned their mind to this often. I also think it's important to recognize there is a perception that there is a formality to these publication ban orders that is not reflective of reality. They are very casual. People, as Mr. Brock pointed out, people will walk into court, it's bail court, and as I understand the Crown policy in Ontario is that you are supposed to ask for these at the first possible appearance. And I don't actually think that's wrong. I think that is erring on the side of protection, but there needs to be the information and the communication to find out if it needs to stay. But when they happen, there tends to be, there's no formal order. There's no form that gets issued. Even when we talk about someone needs to be mailed the order, if a clerk is organized in court, it gets written on the information or the indictment saying there is a pub ban in place. Otherwise, you might have to go and get the transcript of that day's court proceedings to know whether it's been imposed, which also speaks to the problems with tracking how many of these exist. But so there isn't really a coordinated way that deals with, we have 5 victims and these all exist. So it is complicated if one wants to apply later to revoke it and others don't.
If I may, I don't want to be rude and interrupt you, but we're talking about your perspective. Obviously, when there are several victims, there's the possibility that if one speaks about the situation, it might breach the or identify another person. So how can we draft a ban that will be effective and that will respect the rights of each of the victims?
It's certainly possible to do that. And I do think, so assuming that the pub ban gets applied to everyone at the outset and there is a pub ban on everyone, but 2 people decide, I want to be able to speak about this going forward, I think that is the case where that is the only situation where a judge should hesitate to immediately revoke all the pub bans. They should say, I want to think about this and see if there is a way that we can have the pub ban lifted in relation to the 2 of you and not the 3 of you. If, for example, they are siblings and they share the last name and this person wants to speak out publicly, they might still be able to have the pub ban lifted in relation to them as long as they agree to protect their siblings' interests. In that there are some cases where it's going to be more challenging, and that is why that is where there is going to need to be a judge who can weigh those countervailing concerns and decide whether or not the pub ban could be lifted.
Thank you very much, Ms. Stevens. And Mr. Garrison.
Thank you very much, Madam Chair. I want to start by saying thanks to all the survivors, not just Morel, others who are in the room today, and all those who have come forward. It's a very difficult thing to talk about, and some of you may know I'm also an adult survivor. I also thank Laurel Collins, a member for Victoria, because when we started our study on victims, Laurel came to me and she said, I don't think people were thinking about this when they were studying victims. And she said, I really want to make sure that you at the Justice Committee include this in your study, and I can tell you who you need to talk to. So Laurel Collins, as a member for Victoria, was very, very influential. She had a private members bill, which is just running faster. And I guess I would say, yes, I'm frustrated by timing, but both halves of S12 are urgent. And I think, Morel, your comments today really underlined that for me when you're talking about how many times this, I've been trying to get somebody to admit how frequent this is in our society, because this is the most underreported crime, yet we have dozens and dozens of cases before the courts all the time. So I wonder if you could just say a bit more about the frequency and the number of people who are subjected to the bans, not just, I don't want to skip over subjected to sexual assault, but subjected to those bans.
I mean, we, as a group, receive DMs, Facebook messages, various types of correspondence from victims almost every single week from across the country saying, do I have a publication ban? How do I find out? Or, I have a publication ban. My court case ended 4 years ago. How do I take it off? And no one understands how to remove them, how to figure out if they have one, or how to find help. I am not a lawyer, but I've been very fortunate to be connected with lawyers like Megan, like Robin, and others who we refer victims to because we simply can't do that work. But it's so prevalent, and it's so hard to even know how they're being put in place that, like, the ability for someone to just get help and figure out what's going on with their own identity, it's absurd, honestly. Like Megan mentioned, it's very casual. Well, if you're a victim, there's nothing casual about being told you can't talk about your own experience, right? Like it's casual for everyone else except for us. And it's extremely prevalent. It doesn't make sense how the current regime works, and we can't keep doing the work of helping victims ourselves. The law just needs to be changed and clarified so that you take the work away from us, because it's not sustainable and it shouldn't be done in the shadows effectively because people fear criminalization or have various issues in accessing justice.
And of course, obviously, thank you for the work that you're doing. And I hope that the message you've delivered today, all of you, that we need more resources, not just law, applied to this, is being heard around the table. I want to come back to the question of legal aid that you raised, Ms. Stevens. In the legal aid agreements that exist, is this even listed in the categories of things like if people are looking at legal aid programs, I don't remember ever seeing this is a category of legal aid or something that people would even find out if they're looking at brochures and things that it would be possible to have legal aid for.
No, you couldn't get a legal aid certificate for this, for sure. Absolutely not. And in fact, legal aid certificates do get issued to represent complainants in sexual assault cases when there are third-party records applications or applications to admit personal records or sexual history at trial. But those get in Ontario, they get administered by legal aid, so you do get a legal aid certificate, but it's paid for not out of legal aid funding, it's paid for by the province of Ontario, and so I can only speak to Ontario. It is different, but it's not a category of legal aid. Most of this work gets done by lawyers for free, like myself and Robin Parker.
And I would say I know we're out of time, but I would guess it's the same or worse in all the other provinces.
I would guess so too.
Again, thank you.
Thank you very much to the three of you. And I know you've circulated documents to us. I think we have them, but if there's anything else you want to let us know after today, please do. We really want to thank you. I know you came to us months ago, and we very much appreciate it. We've learned from you. It's and it's a topic that, as you mentioned, it affects so many. And you're right. It should not be incumbent on you to be helping. So thank you so much for coming, and thank you today to all the members of the committee. And I wish everybody a very happy Thanksgiving weekend with your loved ones. Thank you very much. We'll see you after the break.